Be good.
Okay, we're back on. No, we're not. I lied. We're back on the record in Mateen Cleaves, 16T538FY. Mr. Manley, I believe you have a motion to make.
I do, Your Honor. In looking at the crowd here today, I've noticed that Monday Township Supervisor and former Police Chief, Mr. David Geiger, is in the audience. As the court could take judicial notice in this particular case, one of the witnesses, one of the first arriving officers on the scene, has filed a civil lawsuit against the Monday Township itself and the Monday Township Police Department, of which Mr. Geiger used to be the chief of police.
Well, what's more important, he is now currently the supervisor.
Correct. He is basically the boss of Monday Township. The sergeant who's testifying here today, at different points in time, there have been allegations that he may be subject to future discipline. There have been a whole myriad of problems that have been laid out in the lawsuit that was filed on behalf of Mr. Ogle. I'm not suggesting in any way, shape, or form that there's wrongdoing, but I think that in this particular, I don't know, you know, when I say not suggesting wrongdoing, I'm talking about today by Mr. Geiger sitting, you know, any of that. But I think it's inappropriate to have him sitting in here as the boss, as he's potentially a witness, possibly in this case, if in fact someone was to come forward and testify that they indeed were pressured by either someone in the department or someone in the government. It's already come out in the testimony, although the court short-circuited it, that there was another police chief that made a call to the Monday Township Police Department after this case had been investigated and kind of pushed it along. So there certainly is a political element to this case, and certainly one could suggest that political pressure was applied in this case. So I'm asking very respectfully that Mr. Geiger be excluded from the courtroom at this time.
Ms. Lindsay?
Your Honor, I'm going to object as it relates to putting him out of the courtroom. My understanding of the case law is that the court has the control of the parties in the case. He is not a party to this case. It is a public courtroom. He has a right to be here. Furthermore, if I could show the court a portion of an investigative subpoena transcript, because there has been, at least from Mr. Manley's argument, that there had been pressure to change what was reported. I have sworn testimony under oath by an officer, and I can let the court read it, where the officer says under oath that there was never any pressure to change the story. And I'd like to present that to the court now.
Not as an exhibit in this case, but merely to help my mind on this motion.
Right. And I believe Mr. Manley has access to that investigative subpoena transcript. If the court can just give me a minute to find the relevant pages, so the court can read.
Two things. One, the case moved on. At the time this was taken, I don't believe the lawsuit was filed.
It was.
Number two.
It was or it wasn't?
I believe it had been.
I think it had been anticipated. I don't think it had been filed. Number two, I'll just make Mr. Geiger a potential witness on my team, and that ends that. I'll ask to be excluded as a potential witness for me.
You can't do that.
I certainly can do that.
Just to exclude, and it clearly is done just to exclude.
No, I gave valid reasons that may indeed, that he may have some information on this case. So, as an officer of the court, I can say that if I interview Detective Geiger, as I knew him, or Chief Geiger, as I knew him.
I knew him as Marshal Geiger.
One and the same. That he could be a potential witness, and I'd ask to be excluded.
Okay, let me ask you a question, Mr. Manley. This court is well aware, and I think I can take judicial notice of the fact that when I was a practicing attorney, I represented defendants that Marshal Geiger was, you know, the gentleman prosecuting the case, the officer, you know, prosecuting the case. What are we going to do here today that won't be made public record once the transcript is typed, that all Supervisor Geiger would have to do is pay for a copy. I mean, if you think that his face in the front row is going to intimidate, then I can move it. But I'm not entirely convinced by your argument that he will hear testimony that he otherwise wouldn't have access to, because the minute these transcripts are typed and filed with the circuit court, anybody can go up and read them.
I understand that. What I'm saying is this officer has already testified to things that he did as a representative of Monday Township Police Department. There's pending litigation.
Not with him.
Not at this time, but I'm sure he'll be a witness in that pending litigation. Supervisor Geiger is a party in that lawsuit. The people, I'm assuming, are going to attack the credibility of Sergeant Johnson.
Well, I would think so.
So if in fact you've got the boss of the Monday Township Police Department sitting here, you've got, and intimidate is a bad word. I don't think intimidate is the word that I want. But it's certainly to have your boss in front of you while you're trying to testify while that township is being sued certainly raises the specter. There's my boss, is this the right answer, and so forth. Why even take that chance?
Do you have an objection to my reading this investigatory subpoena that she's going to hand me?
I don't know what she's referencing.
Show it.
Specifically, Mr. Manley, his argument.
Yeah.
Well, Judge, can I put on the record
Yeah.
the basis, because specifically Mr. Manley in his argument indicated that there was allegations that the officers were being trying, either intimidated or coerced to change their
I
story.
think intimidated was the court word, Ms. Lindsay.
Well, some type of pressure, that they were being pressured to change their story. Mr. Manley indicated that on the record. There's an investigative subpoena transcript with sworn testimony under oath by Officer Ogle when he was asked a question.
Would you show it to Mr. Manley?
And just for reference, page 37 of the investigative subpoena transcript, first question on the page.
Did you have an opportunity to see it? Yes, let's go on the record.
On the page. And Your Honor, for the record, the lawsuit was filed on May 4th, 2016, and that investigative subpoena was taken in 2015, before the lawsuit was even filed.
So that was my point.
But
That
references.
That was my exact point, that things had changed and things had gone on, and there'd been information that had been received, if she wants to go into it, from an Officer Racosta to Mr. Ogle, that he in fact felt that his job was in danger.
Well then...
I don't know, that was exactly what I said.
Okay. The page, if you want to read that, the next couple of pages before that, that was testified about in the investigative subpoena transcript.
Okay, Ms. Lindsay, just a couple of things as I'm looking at this. On page 38, at lines 22 through 25,
Okay, can I just pull
Sure.
mine? Okay, 38 lines what?
22 through 25,
Okay.
even as early as December 16th, 2015, the individual that's testifying has indicated that he's represented by an attorney on some kind of lawsuit. And as it turns out, and I think I can take judicial notice of it, this is the attorney that filed the lawsuit. Puts me in a very precarious position, Mr. Manley, because quite frankly, the courtroom is open to the public. And as I said before, there isn't anything going to come out today that, say, within 2 weeks, although this is a holiday, isn't going to be made public. I guess I could ask the witnesses back in chambers, you know, with the two of you present, whether his presence intimidates them, coerces them, bothers them, whatever.
I think the court has to make that call because certainly the basis of my motion is, in fact, there's a scene in The Godfather where they bring in the brother from the old country.
Yeah, I
And
remember
they sit in the audience. Now, the brother doesn't say anything. Now, the mere fact that he's sitting there is the is the sum of the scene.
Of the intimidation, I understand that.
And intimidation's a bad word. I just think that it would be cleaner if, and I didn't make this a giant point, I just thought it would be cleaner if this gentleman was allowed to testify on things that are very sensitive to both the department and to the township if his boss was not sitting in the front row looking right at him. Now, it may not have any impact whatsoever, but why take a chance?
I can anticipate that this motion would continue to the other anticipated by the court witness, who is Brian Ogle.
Possibly, yes. Well, the motion would certainly go forward. Whether or not Mr. Ogle testifies has yet to be determined.
I don't have a subpoena from you, Mr. Manley, listing Supervisor Geiger as a witness.
No,
Okay,
nor
don't.
would I frivolously prepare one
Right.
unless I had information that he indeed was going to be a potential witness.
But
I-
right now, I'm the truth seeker, and I can see where there might be an intimidation factor as it relates to this witness, and potentially if you call Brian Ogle, and I am going to ask the supervisor to leave during their testimony. He may come back in after and view anything he wants, but I don't want a chance. I want the truth in this case.
Thank you, Aaron.
That's the order. Thank you. I want to note for the record that Supervisor Geiger has left the courtroom.
Thank you, Aaron.
But you understand, he's going to get this testimony anyway, all he's got to do is paper transfer.
It's not so much
It's
that
his presence.
It's
I
his presence,
understand.
and I want a clear flow between the sergeant, and I have great respect for the sergeant,
right.
that he'll do that.
Okay, Ms. Lindsay, ma'am.
Thank you.
Would you like to begin? Are
Yes.
you ready?
Yes, ma'am.
Okay.
Sir, you're prepared to tell the truth here today, correct?
Correct.
And you're prepared to tell the truth no matter who's sitting in the courtroom, correct?
Correct.
Now, last week we briefly, counsel went over your background, correct?
Yes.
And you indicated that you tried to stay current with all the training in the law enforcement field, correct?
Correct.
And you indicated that you do in fact keep up with the new policing trends, correct?
I try to.
Okay, and you try to employ the newest policing techniques at your disposal, correct?
If I'm aware of them.
If you're aware of them, correct? Now, prior to 9/15/15, you had no specialized training in sexual assault investigation, correct?
Only in the academy.
No specialized training, correct?
Correct.
Only what you got in the academy, correct?
Correct.
How many years ago?
It would have been about 19.
About 19 years ago, and you would agree with me that there have probably been advances in how to deal with criminal sexual conduct since 19 years ago, correct?
Correct.
So other than, in the academy, basically the academy is basically a 3-hour course on criminal sexual conduct, correct?
I have no idea how long it is.
Okay, but you don't remember it being an extended course, correct?
It was 19 years ago, ma'am. I have no idea how many hours it was.
So you cannot dispute whether or not it's only a 3-hour course, correct?
Correct.
So potentially, a 3-hour course 19 years ago was your only training.
Wait a minute, Miss Lindsay. You keep referring to this 3-hour course. You're assuming facts, not evidence. This witness has said, I don't remember how long, it could have been a whole day, it might not have been anything there at all, so.
But he said he couldn't dispute it.
Well,
Okay, so.
I'm disputing it.
Okay. Now, and certainly you have had no training in trauma-informed response to sexual assault, correct?
Correct.
Excuse me, Miss Lindsay, trauma what?
Trauma-informed response to sexual assault. You've never been a lead investigator in or an OIC in a criminal sexual conduct case, is that correct?
Correct.
And you are aware there are various forms of criminal sexual conduct, correct?
Yes.
Okay, but you cannot, you do not know the different types of criminal sexual conduct, do you?
The different degrees?
Yes.
Well, obviously there's varying degrees, but I can't quote them off the top of my head what the differences are between
Okay, so
all.
you don't know the difference between criminal sexual conduct 1, 2, 3, or 4, correct?
I wouldn't say that, no, ma'am.
You said you do or you don't?
Well, I know parts of them, yes. I can't recite the exact laws, but there's
Okay,
obviously
so
differences between them.
You are aware of criminal sexual conduct being effectuated by intoxication, correct?
I wasn't aware.
You were not aware of that, correct?
I guess I don't understand the question.
That question, number one, is obtuse. Number three, number two, it misstates the law because there's no criminal assault by intoxication. Now, there's levels and degrees of criminal sexual conduct in which criminal intoxication may indeed play a part, but to say criminal sexual conduct by intoxication, that there's no such crime. And the question was improper, and the officer has indicated that he knows, it's been asked and answered, that he knows the degrees. He couldn't recite them line by line today as much.
She may ask him if she understands the effect of intoxication on this, but other than that, I agree with you.
Thanks, Judge.
So you are not aware that a form of criminal sexual conduct could have an intoxication component, correct?
I'm sorry, Miss Lindsay, even I don't understand that question.
My question to him is he does not know whether criminal sexual conduct in the state of Michigan can have an intoxication component.
Are you talking about on the victim's side or the defendant's side? Or both?
As it relates to the statute.
Okay.
Judge, again, I'm going to object it. He's an investigating officer. He can testify as to what he saw, what he did.
He's not a lawyer.
Why he's not a lawyer.
Right.
I think that's beyond the scope of this witness's knowledge, and nobody put him up as an expert on criminal sexual conduct. Nobody put him up as an expert on the laws of criminal sexual conduct. Nobody put him up to discern the statutes. That's
Well, I want to hear his
What
answer.
happened?
Okay, I want to hear his answer to this question. I think it's an important question. But I want the question asked in a way that the court understands it. And if you're referring to a specific statute, Ms. Lindsay, and you want to ask the question the way you want to ask it, just give me the statute so I can read it first.
Okay. the statute would be the charging 715. Hold on, Judge, I'm getting this for you.
Okay, sure.
Yeah. 750, 520,
Here, let me get to it.
D1C.
Let me get 520. 520 what now, ma'am?
D1C.
D1. So I'm starting out, a person is guilty of, is that Mr. Muscat? Is that, am I starting out in the right paragraph? A person is guilty of criminal sexual conduct, and then it goes on and picks up at D, that the other person is related to the actor by blood or affinity. Am I reading the right?
No, they're variables. That's
What, you're trying to get me to the variables?
Yes.
Okay, so
Judge, I
let me
have a
make sure I
copy of
have
the
it.
information. I'm sorry, it is a little easier to follow if you just look at the information.
Is it on the information?
Right,
Yeah.
it's a reference to...
Of course, you realize there's no information in district court.
The complaint
Excuse me,
warrant.
the complaint. That lists the different factors each count is charged under. And then it cites out to the statute.
Okay, I've got it. Now,
Well,
oh, you were
well,
saying
well,
G as opposed to D as in dog. Okay, now let me look at it.
No,
Judge, well, let me just briefly, if the court looks to the criminal jury instructions defining criminal sexual conduct in the third degree, it's 75520 D1C, and it says that the
Mentally incapable, mentally incapacitated, or physically helpless, doesn't mention any intoxication.
But yes, it does, because the last part of the statute says that the defendant knew or had reason to know the complainant was mentally incapable at the time of the alleged act.
This is the mental incapacity that
Incapable
you're
based on
alleging.
intoxication.
Okay, let me read it. Just
Is that including drug use as well, or just intoxication by way of alcoholism?
Whatever he had reason to know based on what he saw and observed of the complainant.
Which she was fine. She said she wasn't.
And which one of those three, Miss Lindsay, you're allegedly
Incapable
incapable?
due to intoxication.
Okay, I don't see intoxication as listed there. Do you have case law that lists
Yes,
intoxication?
intoxication, law talks about intoxication,
Okay.
yes.
Not right now, but when I take my lunch break, I'd like to see that case law, because I interpreted this whole section as different. I thought we were talking about a real mental incapability, like a low IQ, some kind of learning disability, something like that. So I want to look at the case law on 750 520 D1C. All right?
Okay,
Now,
Okay.
with that in mind, Miss Lindsay,
yes.
I just want to say you're confusing this court in the way you got your question worded. I'm not trying to control your cross-examination, ma'am, but I need to understand the question.
Okay. My question to you is, sir, were you aware that criminal sexual conduct could be committed on a person if they're too intoxicated to consent? Were you aware of that?
Well, I think the law,
My question to you, that's a yes or no. Yes, you were aware, or no, you were not.
well, I think the law states that incapacitated, right? So whether or not that person is intoxicated would depend on whether you decided that was incapacitated or not. So was I aware of,
So the question was, were you aware of that? Yes or no?
yes.
Okay.
I don't know what he was aware of.
Were you aware that a criminal sexual conduct can happen if a victim is too intoxicated to consent? Yes or no?
I don't think the law states that, ma'am.
So you don't believe the law states that?
Can I read the law? I mean, you have a copy of it.
My question to you
Judge,
is,
may I object? It's argumentative. I think what he said was, he understood, and she didn't appear to be incapacitated to him.
That's what I think he's
understood
saying
him to
too.
say.
okay, that wasn't my question. My question was he aware that the law,
Outside the scope.
no,
He's not a lawyer. He can testify as to what he saw, what he did.
he made a determination, and he testified that he didn't believe any crime had been committed. My question to him is, specifically as it relates to this statute, was he aware at the time that intoxication, you cannot consent if you're too intoxicated? Were you aware of that?
It's not what the law says, Judge. The law is clear. The court can take
Okay,
judicial notice.
first of all, I'm going to say this. I believe it's outside his, I think he'd have to be a lawyer to be able to do that, because even I sat here and I've heard many cases and said, wait a minute, I thought you meant something else on the complaint. So I think you're outside this gentleman's, I don't think he can testify to it, Miss Lindsay.
Okay, okay. When you encountered the complainant at the scene, she was highly intoxicated, correct?
Yes,
She was too intoxicated to drive, correct?
she was, in my opinion, she was highly intoxicated, which I would categorize as too intoxicated to drive, but sober enough to answer my questions.
Okay. Now, you also talked about last week the commendations and the honors you received in the past. Is that correct?
I have received some, yes.
Okay. But you didn't receive a commendation for your actions in this case. Is that correct?
Correct.
You were disciplined for your actions in this case, correct?
I was.
You were suspended for your actions in this case, correct?
I was suspended
You
and
were
held in a...
correct? That's a yes or no. You were suspended, correct?
No,
You were not suspended for 3 days?
I didn't serve any time off, ma'am. I was going to explain that to you.
So you're saying you were not suspended for 3 days?
Actually, it wasn't 3 days, no.
Okay. But how many days were you suspended for?
I wasn't suspended for any days, ma'am. I tried to explain that to you.
Okay.
I was disciplined and it was held in abeyance, so I didn't serve any time and take it on my file.
You were disciplined, but what?
It was held in abeyance.
Held in abeyance, but the actual discipline was 3 days, correct?
No, ma'am.
Okay.
It was 2 days.
Okay, 2 days. And you did not appeal that discipline?
No, because at the time...
That's a yes or no question, sir. Judge, that was non-responsive.
Excuse me, excuse me,
Could the...
excuse me. It's a yes or no question.
Okay.
You can clean it up on redirect.
And there were complaints concerning your actions that night, correct?
By whom?
Does he know, I will phrase,
Thank you.
do you know whether there were complaints about your actions that night?
Not to me, no.
Now, so you're not aware of, my question to you was, and listen to the question, were you aware, yes or no, of complaints being made against you for your conduct that night?
Yes.
Okay, thank you. Now, the total time, and as a result of your handling of this situation tonight's end, did you have to have some mandatory training on how to respond to a sexual assault case?
The whole department did, ma'am.
And if you're a part of the whole department, you in fact had to take that training?
I attended, yes.
Now, the total time you spent at the night's end from start to finish was approximately 29 minutes, is that correct?
I don't know the exact time.
But reviewing your activity log for that night, perhaps refresh your recollection as to the exact time?
Sure.
That brings up a question, Miss Lindsay. Did you ever provide him with a copy of his investigative subpoena testimony?
Yes, he read it this morning, Your Honor.
Okay, thank you. Lieutenant.
I'm handing you now what purports to be a copy of the activity log. Does that in fact refresh your recollection as to the exact amount of time, total amount of time you spent on the scene that night?
Yes,
Approximately 29 minutes?
correct.
And that 29 minutes included you driving the defendant home, correct?
Yes.
Now, prior to going to the night in, you were apprised of the nature of the call, is that correct?
I was dispatched to call, yes, ma'am.
Okay, and it was a trouble call, correct?
Correct.
And you were informed of the nature of the call, correct?
I think the dispatcher said that a male was pulling a female back into the room.
Okay. Now, when you go on these types of calls, and it was the nature of the call was a trouble call, correct?
Correct.
And when you go on these calls, you never know what you're walking into, is that correct?
Correct.
You don't know how serious or dangerous it is before you get there, correct?
Correct.
So you have to be prepared for anything, correct?
Yes, ma'am.
You have to be alert and focused, correct?
Sure.
And you have to approach the scene in a manner where you can hear and observe everything, correct?
Yes.
And not be distracted by anything, correct?
You're trying to not be distracted, yes.
Okay. And when you go into a call like this, the more you know about what you're going into, the better it better helps you to respond to what you're going into, correct? The more information you have when you're approaching these calls, the better able you are to determine how you're going to respond, correct?
Most of the time, yes.
Okay. And when you approached the situation, were you approaching it as a serious situation?
Yes.
And prior to going to this location, did you know the identity of the person who you were going to, the trouble call was related to?
Of the suspect?
Yes.
I believe I did, yes.
Okay. And you know it to be Mr. Cleaves?
Yes,
You see Mr. Cleaves seated in the courtroom?
I do.
Could you point him out and tell me what he's wearing?
It's already been identified, Judge.
I can do it with this witness, Your Honor.
And the point of doing it is what?
Because I always do it with every witness. I put the identification on the record with that witness.
I did it on direct, it's cumulative, stipulative, there's no...
Okay,
We'll
stipulation.
just stipulate
Okay.
to
There's
it.
no reason to do it.
Okay. And prior to going to, once you found out it was Mr. Mateen Cleaves at this incident, had you had prior knowledge about him at hotels?
Judge, I mean, are you kidding me? Move for an immediate sanction to that question. I mean, that once again, this is why I made my motion for a dismissal. This is why we had making of a murderer, now we're trying to have making of a rape. I mean, are you kidding me? Can we approach, Your Honor?
Yes. How is it that I'm more worried about
It's not, it goes to the period. What his idea about why
I'm not allowed to know. It's overruled. I mean, it's the same. No, I'm all done. It's the same.
No. You got the issue.
And you know, you can shake your head and go, oh, Judge, all you want to, but I am sustaining the motion.
Thank you, and I'd like the record to reflect, you got the issue.
Okay, wait a minute. We need to get back on the record. I am
Can I make
I
my
am
record as to why?
sustaining, wait a minute,
Okay.
the record just started again. Let me say I am sustaining Mr. Manley's motion.
Can I make my record as to why it's relevant and important? The
Make
court
the
has-
record.
Okay.
Judge,
I
you can
asked-
disclose facts, not in evidence. This is the same lady who stood up and said there was a second person.
I
out there.
know it,
So
I'm not-
this is completely wrong. She knows it's wrong. Does she want, I mean, I've got stuff here that's in, you just can't do it.
You know,
And
and let me
there's no
say
record
this.
to be made.
Let
Court
me
ruled.
say this, okay? I don't know what the big deal is. all right? This defendant is an ordinary human being. We are not dealing with the President of the United States here, or the President-elect. Yeah, I'll agree there's some degree of, what's the word I want? Celebrity, but he's an ordinary citizen to be treated with fairness, and I don't think this question, you know, oh, it's him, no, I'm sustaining it.
Thank you.
Now, you can make your record, but I'm not gonna listen to it. I'm just gonna let you make it for appellate reasons.
Okay.
Judge, I'd ask, I mean, if she's going to be able to slander, and I don't know what she's going to say, but somehow throw something out.
She may not talk about any prior incidences she knows about, that's for sure.
Well, that's what I think she's intending to do.
She's not gonna do it, because that's 404 or 403B evidence, and I'm not gonna allow it.
Thank you, Judge.
Unless she can show me that there's motive, pattern, scheme, or design.
This testimony is not going to Mr. Cleaves, it's going to the officer's state of mind when I asked him, did he take this call as serious?
He said he took it serious.
I understand that, Judge, but I don't have to take him at his word just because he says it. Because if I had information that may have impacted on him taking it less serious than he claims he took it, the court is entitled to hear that. If the fact that he had known about some other things made him take this less seriously, I think that is something the fact finder needs to know about.
I don't think this fact finder needs to know anything more at this juncture other than this, as Sergeant took this call seriously. This may be a proper subject for trial. I wouldn't deny that. But it's not down here, and I'm not going to listen to it.
Well, then, can I ask, I'm not going to ask, did the fact that it was Mateen Cleaves make you take it any less or more serious than you would have otherwise?
No?
Now, you're driving up to the Nice Inn, correct?
Correct.
Officer Ogle is in front of you, correct?
Yes.
You have your, you're in your scout car, correct?
Yes.
And your scout,
Ms. Lindsay,
I mean,
excuse me, for just a minute.
Yeah.
I admit I'm old and I'm stuck in a habit. Could you call it a cruiser? Because
Yes.
scout car just has no meaning to me at all.
Police cruiser, correct?
Yes.
And your police cruiser has the ability to report, correct?
Yes.
And as you were pulling up to the Nice Inn, did you view Mr. Cleaves' vehicle?
I did.
And it was leaving the area or attempting to leave the area of the hotel, correct?
It was initially parked, and as we pulled in, it started moving.
Okay, start moving toward getting out of the hotel.
Towards the exit, yes.
Correct?
Yes.
And as you approached the Mr. Cleaves' vehicle, he did not stop immediately, correct?
He continued, as we pulled in, he was pulling out.
Okay, let me back up a little bit. Did Officer Ogle position his car in a way to try to block Mr. Cleaves from leaving?
I don't know if he did or not.
Did Mr. Cleaves attempt to go around Officer Ogle's car before he stopped?
I don't know if he drove around or if he was driving in a straight line or not, ma'am.
Okay. You were in Scout Car 29 that night, correct?
Yes.
Are you saying you don't know or you don't remember?
I don't recall.
Okay, you don't.
Correct.
Yes.
Okay. I move for the introduction of People's Exhibit 102 evidence, the video of the police cruiser.
Mr. Manley? Is it a video or is it just a still?
It's a video.
And do I still have the monitor sitting over here?
There's no nudity or anything.
Okay.
So,
But you'll answer my question. It's not-
I don't know.
There's two men.
Okay.
Okay.
Mr. Manley, do you have an objection?
Yeah, I do at this time, because what we have here is just a scout car video. There's 4 cars.
Now you're calling it scout car.
That's because that's how they list it. There's 4 cars on this scene. So there is 3 from Mundy Township and 1 from the Genesee County Sheriff's Department. It does not identify which car it's from.
Well,
No, well, what? I mean...
Mr. Muscat?
Yes, Judge.
Muscat, I'm sorry. Can you, do you have a way of identifying that Exhibit 100 is this sergeant's cruiser?
yes, as a matter of fact, I can, the actual stills from it, I had the video and the stills, 103 through,
Show them to Mr. Manley, please.
133 inclusive.
Judge, I'm looking at these. These were not admitted prior to the prosecution resting
That's right,
their
they
case.
weren't.
Because
I
that's
don't
what
know, I'm not admitting them. The proper foundation has not been laid as to which particular car they're from. I'm going to object for those reasons.
Well, I have
I
a further question that I want you to address. Can they admit exhibits? Because, see, Mr. Muscat tried to introduce all their evidence, all their exhibits at the end, and I said, no, she rested. Can they introduce their exhibits during their redirect? I don't think so.
No,
Absolutely.
This is not,
You give me the case law on it
this
right
is
now.
not redirect, this is
cross-examination, I'm sorry.
This is cross-examination, and this witness did not testify during my case in chief, so that's why they couldn't come in, because without foundation. But if he calls a witness, I am allowed, if he
Okay,
calls a
all right,
witness.
fine, I buy it.
Okay,
All right, now address his objection.
as it relates to this witness can testify as to what scout car he was in. By way of foundation, you were in scout car 29 that night, is that correct?
Yes, ma'am.
Okay, and I can ask him to look at these still shots and indicate that they come through from scout car 29.
Cruiser 29?
Sorry, police
That's right.
police car 29.
Mr. Manley, what was your objection again?
My objection was, Judge, that they had rested.
Mhm.
That it was not that the court, they attempted to put them in. At that time, the court declined because they had rested. She just tried to move them without, now she's backpedaling, I can show. So clearly by her own admission, she's saying she has not done it properly to this time. So there's no foundation at this point. If she can lay a proper foundation and the court agrees that she can do this at this time, obviously the court can accept that. But at this point, by counsel's own admission, she says, I can have him do this. So,
Well, she chose not to call him.
yeah,
He was her witness.
correct.
In terms of admitting them for purposes that that's his car, what's the problem?
I don't have a problem with that.
Miss Lindsay, you may show
If indeed
him,
that's his car.
you can show him a picture of his car and ask him if that's his, and I don't have a problem with that. But you're standing there with sheets and sheets and sheets of paper. I don't know what you're trying to admit, and I haven't heard a foundation.
Well, I'm getting ready to now.
All right?
Okay, I'm asking you to look at 103 to 133 inclusive, and ask you to look at, are these screenshots from your scout car video from that night? And, excuse me, patrol car, cruiser from that night.
You know what, it's just easier to change me than it is you two.
had an opportunity to look at those photographs?
Move that camera up. Thank you, go ahead.
Yes, ma'am.
Okay, and do those photographs reflect the screenshots taken from your scout car video that you were driving that night?
Yes, ma'am.
Move to the introduction of 100, which is the actual scout car video, as well as the still.
I'm still having difficulty with whether or not you can admit evidence on cross when you have rested on your case in chief. I can't remember that happening in this courtroom. What I'm going to do is say I've already seen this video.
You have not.
Well, maybe I didn't, but maybe I should have. What I'm going to do is red star this, and I'm going to ask you for case law that shows that I can accept these exhibits during cross-examination, because I just have never done this before. Not saying you're not right, I just have never done it before.
How many times has somebody called a witness at preliminary exam?
How many times has in a criminal case, and that's all I've done for 8 years, criminal cases.
Sure.
How many times in a criminal case have they not called the responding officer? Once. This one.
Judge, a witness found, the exhibits can be laid with, found can be laid with any witness, Judge, and we'll certainly look, but that is an accepted practice. I don't think Mr. Manley would even dispute that.
It
The
might be
foundations can be laid with any witness, Judge.
That might be accepted, Mr. Muscat. I'm not saying you're wrong and she's wrong. I'm just saying it's new to me. I want to see case law. I'm gonna just let me finish. I'm going to star them. I may admit them. I want to see case law. I'm very upset in terms of the order of things that this witness was not called.
Judge,
I'm talking. I'm upset from the aspect that this is the people's first responder, and you chose not to call him. That sends a certain message. Go ahead, Ms. Lindsay.
Your Honor, I am not obligated to call him as a witness. And second of all, these exhibits could not be properly authenticated through any other witness. That's why when counsel decides to call witnesses,
I will take the case law on it, and then if I decide against you, you can argue at the beginning of the afternoon session. Please move on.
So you're not letting me put the video in at this time?
Have we already admitted the video?
No, we admitted a small portion of that video.
Because I remember seeing...
We admitted the portion of the video where he spoke to Colleen, when Colleen Dodell came in. We did not introduce the whole video where it shows the approach, that shows how the cars, when Mr. Cleaves did not stop. And
is he charged with fleeing and eluding?
It does not matter whether he's charged with fleeing and eluding or not. The court is entitled, and we are entitled, to put on the evidence that shows that he did not initially stop.
Why?
So that goes to consequence of guilt.
Overruled. Go on.
Your Honor, the
overruled. Go on. Don't argue with me.
Okay. So you're saying, without a doubt, that Mr. Cleaves definitively stopped the minute the police cars came on the scene. Is that what you're saying?
No, ma'am.
Okay. Did he, in fact, maneuver around Officer Ogle's car?
I don't know his exact path that he drove, ma'am.
So you can't dispute that, can you?
I don't recall his exact path that he drove his vehicle.
Okay, but reviewing the video, refresh your recollections as to the path he took.
Miss Lindsay, we are not, Mr. Cleaves is not charged with fleeing and eluding. What relevance does whether he drove around the car, whether he hit the street, whether he didn't hit the street, have to do with what purportedly took place in room 101?
Because attempted flight.
I don't know it was attempted flight.
And you won't know
not
until you see
necessary.
it.
Judge,
Attempted
I'm
flight.
not going there.
thank
It's
you.
overruled.
Thank you, Judge.
I mean, you're sustained.
Thank you.
the officer testified on direct court heard. And as soon as the
He
lights went
said
out.
the minute the lights came on,
Stop.
Cleaves got out, put his hands up.
Right. So, I mean, this is ridiculous.
I'm just not going there.
Thank
Okay.
you, Judge.
Running, and there's a lot of case law on it, running is not indicative of guilt, so I'm not going there. Stay relevant.
There's a criminal jury instruction right on point, Judge.
Stay relevant.
Okay. Now, when you first got on the scene, you encountered Colleen Dodell, correct?
He encountered who?
Colleen Dodell. Before you got down to the room, you encountered Colleen Dodell, correct?
Yes,
Okay. And you spoke to her for less than 10 seconds, correct? Or she
Uh-huh.
spoke to you, correct?
I don't know the exact time frame.
Would you dispute that it would be approximately 10 seconds?
I have no idea how long it was, ma'am.
You go down to the room, is that correct?
I did.
And when you went down to the room, you encountered, exhibit number 7, which has been admitted.
Yeah, I admit 7 has been admitted now. What part of 7 do you want to refer him to? One is full and one is approximately 40 seconds.
Oh, no.
7.
7 is full, and then 8, 9, and et cetera are clips, Judge.
Okay, oh, 8, I got it now. All right, thank you, I got it now. 7 has been admitted. Are you gonna play the whole thing?
No.
Okay.
From 5:46:33 to 5:46:57.
46, 43, to what?
33 to 5:46:57.
Is this the part, there's nothing in this replaying of this exhibit that shows any
Correct.
nudity,
Correct. Correct.
Mr. Muscat, is my Polycom ready to operate?
Yeah.
Are you all plugged in and everything?
Yep. I have to cue
Sure, I
this-
understand.
cue this up. before I
Mr.
can
Manley,
play.
do you have any objection to this?
No, Your Honor.
No? Okay, then Mr. Muscat, you may proceed, sir.
Judge, I just have to get the time exactly right.
Okay, sure.
5:46:33 to 5:46:57.
And do I need to bring the witness so it's not to his back?
I guess maybe he can step down, and so he can see it.
Sergeant, would you come here so whatever they direct you to, we've got you on the microphone? There's a green light there, so I'm assuming it is. I'll let him chew it out.
Yeah, it's on, Judge. I have to open it a particular way since I'm...
You're fine, Mr. Muscat.
Okay, for the record, it's listed at 5:46:32, so I can start playing it and I'll stop it.
Okay, just let me ask Ms. Lindsay one question.
Yes.
Ms. Lindsay, you see the car that seems to have headlights on it,
Under
right
the
there?
C for the record?
Yeah, is that the car you're referring to?
Which car?
The one that, Ms.
I'm pointing
Right
at
there.
it with this mouse.
Is that the car I'm supposed to watch?
Yes.
Okay, thank you.
And just, and the court, I already know that the court understands that the continuing objection to the actual times on the video.
Yes, that's noted for the record.
Thanks, sir.
Okay, starting. Okay, and I played it to 5:46:57 as indicated.
Okay. Officer, you can return to your seat. Officer, that was you arriving at the scene?
Yes, ma'am.
Okay. When I say at the scene, I'm talking about the actual room 125 where the complainant was at?
Correct.
Okay. And there was a gentleman standing out in front of the room?
Yes,
At no time did you get his name, phone number, any contact information, correct?
I did not.
Okay. And when you went into the room, you did not have any extended or detailed conversation with him at that point in time, is that correct?
Correct.
Okay. Now, earlier you indicated you like to take advantage if you have access to it, to current techniques to help law enforcement, is that correct?
Sure.
Okay. You have a body mic?
A what?
A body mic?
I
You
do
have
not.
access to a body mic in your car?
There is one in the car, yes, ma'am.
Okay. And does that actually do audio, record audio?
That doesn't work, but
Okay.
it would.
My question to you is, does it record audio?
No,
You're saying the body mic in your car did not work that night, correct? Is that what you're saying?
I'm saying it doesn't work, period.
Okay. Do you have, your scout car has the capability of both audio recording and video recording, correct?
Yes.
That was working that night, correct?
The audio inside the car?
Yes.
I believe so.
Okay. And also the video inside the car was working, correct?
Yes, ma'am.
You did not, in fact, have the complainant sit in the car, so what she said was audio or video, correct?
No,
You did not have any of the witnesses on the scene sit in the car to have anything that they had to say video recorded or audio recorded that night, correct?
correct.
And certainly, that would have been a more accurate depiction of what was said to you, correct?
Not necessarily.
You're saying a video would not be more accurate than you simply recounting from memory later?
I guess it depends, ma'am.
Okay, that depends. Now, earlier you testified that you spent approximately less than 10 minutes with the complainant, correct?
I thought I said 10 minutes, but approximately 10 minutes.
10
might have
minutes
been.
or less, correct?
I don't recall my exact statement, but I would say approximately 10 minutes.
Okay. You spent more closer to 6 minutes with the complainant, is that correct?
I don't know how long it was, ma'am.
Okay. I'm going to ask you to look at People's Proposed Exhibit 81 through through 88 inclusive.
Okay, excuse me just a moment, Miss Lindsay.
Yes.
81 through 88 inclusive. have not been admitted,
I know.
and, wait just a second, let me make a note. 81, did you say, through 88? Is that your numbers, ma'am?
Yes.
Okay. They have not been admitted into evidence. Again, I repeat, I'm not sure you can do this on cross, and so I'm going to star these exhibits.
Thank you, Judge.
Okay.
I'll have the continuing objection. What clearly has happened here is the fact that the responding officer, the first one on the scene, have not been called. It's
I
a
understand that,
sandbag,
ma'am.
trick type situation that goes against the obligation of Kim Elworthy's prosecutor's office to do justice, not to try to trick somebody into something.
I
And that's what we
understand
have
that.
here.
That's why I'm starring this.
Thank you, Judge.
Go ahead, Miss Lindsay.
The video, 7 has been admitted. So let's start with Mr. Muscat.
Are you going to replay the video, ma'am?
No, there's another portion of the video. Could you start at, well, let me just wait. You would not dispute if the video shows you going in the room at 5:46:59, and then you coming back out of the room at 5:52, that's approximately 6 minutes. You wouldn't dispute that, would you?
Well, at one point, ma'am, I came out of the room to try to call her mother in my car, and I believe I went back in the room, so I don't know if that is what you're talking about or not.
My question to you, sir, is you would not dispute if the video showed that you were in the room approximately 6 minutes the first time, you would dispute that, would you? If that's what the video showed.
Pardon me.
She's cleaned up her question.
Okay.
I'm gonna,
All right.
she said the first time.
My
So I'm
my
gonna
problem is that the first question, again, going to the misleading of the tribunal, is that you wouldn't dispute as if there were only one.
I
And
understand.
it's a continuing pattern. And
I
it asks that
understand.
counsel stay with what has actually happened here. It's dishonest.
Ms. Lindsay, please be more precise for the court and for no one else as to what you're referring to, okay?
I'm talking about the first time.
Thank you.
What was the question again, ma'am?
If the video showed that you were only in the room for approximately 6 minutes for the first time, you wouldn't dispute that, correct?
Correct.
Now, you just said here that you actually tried to call the victim's mother?
I did.
You did.
I did, personally, yes, ma'am.
Okay. Did you testify previously under oath at the investigative subpoena
I did.
transcript? And you were testifying truthfully then?
I did.
Did you in fact at that time say you did not try to call, that you had you had the people at the scene call?
I don't recall saying that, ma'am.
Now, when you first saw the victim, the complainant, did you see signs of injury?
She had a circle of blood on her knee about the size of a half dollar.
And you did not record that in any report, correct?
Correct.
You did not seek medical attention for her, correct?
She refused medical attention, ma'am.
That was not put in any, let me back this up. That was not documented in any report, correct?
No.
Okay. And as it relates to being an officer, one of the things you always have to be cognizant of is the fact that there may be civil liability for your actions, correct?
Correct.
And that type of thing would have been something you would put in your report if it were true and you noted it, to prevent some type of potential civil liability, correct?
I guess it depends, ma'am.
But you didn't, correct?
She was offered medical attention,
My
refused
question
it.
to you, sir, is, listen to the question.
Okay.
You did not list that in any report, correct?
Correct?
When you testified at the investigative subpoena, when we were talking about injuries to the victim, you did not say that, correct?
I wasn't asked that question, ma'am.
My question to you, just like you're not, but you're volunteering stuff here today, correct, that I haven't asked you, correct?
What's your objection?
My objection is twofold. One, this is the same investigative subpoena from 2015 that was withheld Okay?
Yes, I understand.
Now she's attempting to, because she says Detective Neri handed it to him this morning, which is well over a year. She's trying to impeach him with it.
Well, she stopped at short of impeaching him with
Okay.
it.
My objection is that this mischaracterization of the sergeant's answers. I have faith that the court can hear. That's fine.
The court is paying attention. I'll note your objection, and please continue, Ms. Wood.
Now, you are volunteering answers here today that I have not asked you, correct?
I'm trying to answer truthfully, ma'am.
My question to you is, you have volunteered, I've asked you yes or no questions, correct?
Yeah?
And when I've asked you yes or no questions, you have volunteered information, correct?
Sometimes, yes.
Okay. So did you claim that the reason why you didn't say that in investigative subpoena is because you weren't directly asked, correct?
Correct.
Okay. Now, there was a female officer on the scene, correct?
Yes,
There
ma'am.
was a what?
A female officer on the scene, correct? And that female officer was also an EMT, correct?
I believe she's a paramedic.
Okay. So you had a paramedic at the scene that you did not take down to the room, correct?
She didn't go down there.
You did not take the paramedic to the room, correct?
I didn't take her down there, no, ma'am.
As a matter of fact, you didn't even inform the paramedic that there was a woman who might have injuries, correct?
Was there injuries, or are we talking about the scraped knee that the nurse said was some,
He said
That's not
there was
illegal.
one injury. She's using it plural.
yeah, that's what I'm saying.
But you note that the court is noting it.
Okay. I mean, once again,
You did not tell the female paramedic who was on scene that there was a woman down in the room who had a injury, correct?
No, ma'am.
Now, the victim, when you saw her, she was emotional, correct?
Yes.
Crying
Yes.
and intoxicated.
Yes.
And you said she was highly intoxicated,
Yes.
correct?
Yes.
She was too intoxicated to drive, correct?
Yes.
And you did nothing to assure she understood what you were talking about when you spoke to her, correct?
So she understood my questions.
My question to you was, you did nothing to assure she understood your questions, correct?
I don't, he said that she understood. He's testified on direct, he's testified here today that he did everything. How can,
What's your objection?
assumes facts not in evidence, and it's a question that clearly the officer doesn't understand. And it'd be
That's nothing the court doesn't understand. Would you two approach?
Sir, you were asked a series of questions during the investigative subpoena concerning how you deal with a highly intoxicated person. Do you recall that series of questions?
I don't recall off the top of my head with it or no.
Now, when you are talking to an intoxicated person, is it incumbent upon you to make sure they understand and they're tracking what you're asking?
Yes.
And did you do that with Ms. Brindell?
I guess I don't understand the question.
Okay. You answered these questions at the investigative subpoena, correct?
Did
You answered these questions at the investigative subpoena, correct?
I don't know what question is referring about.
Okay, well, I'll put you on page 16 and ask you to look at page 16. As it relates to your training, you can't take a statement from a person who's intoxicated, correct?
Judge, wait, whoa. That is completely inaccurate. And you can take a statement from somebody, and if she's not going to differentiate between a suspect and a witness, then it's an improper question and a misstatement of the law.
He can
That's what
answer the
she's trying to
question,
do.
Judge.
It's a misstatement of the law.
Well, no, actually, it isn't a misstatement of the law. She's just asking, in my opinion, she's asking, is he allowed to take a statement from a person that's drunk? He can answer that
Okay,
yes or no.
that's fine, because I've got the subpoena where she's headed with this, that's fine.
Well, but she allowed him to refresh her memory, but she has not then said something else. She's
Okay,
just asking.
that's fine.
So I'm going to overrule you, Ms. Mann.
Thank you, Judge.
Can you answer the question?
Can you ask it again, ma'am?
As it relates to that in your training, you know you can't take a statement from a person who's intoxicated, correct?
You can take a statement from a person who's intoxicated.
You answered that question under oath at the investigative subpoena, correct?
I did.
Page 16, and when I asked you that question at the investigative subpoena when you were represented by counsel, you said correct. Wasn't that your answer?
I think I was referring to somebody who was so intoxicated they were unable to make sense of what was going on.
You did not say that though, correct?
My response at that time wasn't that, no.
Excuse me, I didn't hear that.
Did I say that at the time?
Right.
No.
You simply answered correct without clarifying, correct?
Correct.
And you could have clarified, correct?
I think I just did, ma'am.
No, I'm talking about back then, sir.
I could have done what?
You could have clarified back then when you gave your answers under oath, correct?
I could have, yes.
And there was nothing prohibiting you from doing that at that time, correct?
Correct.
You did not wait till she was sober.
No, ma'am.
You did not ask the female EMT to come assess her level of intoxication, correct?
No, ma'am.
And when you spoke to the victim, she repeatedly asked for her mother and her boyfriend, correct?
Yes.
And you would agree with me taking a statement from a drunk driving suspect and a potential criminal sexual conduct victim who's highly intoxicated. Those are two different situations, correct?
Judge, if in fact, objection, if in fact we're talking about a potential sexual assault victim, I believe that assumes that the officer testified untruthfully when he testified on direct examination, because not only did he say that there was no criminal sexual conduct, he said that this woman indicated that there had been no criminal conduct at all, no assault at all, no criminality of any sort. So the question assumes facts, not evidence.
I understand that, but I think
And it's irrelevant if it's irrelevant if she's in fact stating that it applies to this case, because at this point, this officer had no information there had been any criminal sexual conduct.
And I understand that, but I think she's asking a more generalized question. Ms. Lindsay, let me make sure I understand.
Uh-huh.
I think she's asking, in his experience at 19 years as an officer, wouldn't he question a drunk driver differently than he was questioning a potential victim that was drunk in a sexual assault case?
That's
I
fine.
think that's what she's asking.
Correct. You would handle those situations differently, correct?
Yes, ma'am.
Now, as it relates to everything that happened in terms of what the complainant indicated to you, you chose not to record, correct?
Record with what, ma'am?
You indicated that your video was working in your car and the recording device was working in your car. You chose not to record what she told you, and when you record, you chose not to record your encounter with her, correct?
Correct.
And that was the choice you made, correct?
Yes.
There was no reason for you not to do that, correct?
I have no reason to not do that, no.
Okay. And this is fairly important information, correct?
Potentially.
Now, there is no witness to verify what you said she said to you in that room, correct?
Ms. Dowdell was there for part of the conversation.
She was not there the whole time. You put her out the room, correct?
I asked her to leave the room, yes.
So, she was not there the full time, correct?
Correct.
The point in time where you claimed that the victim said she was not sexually assaulted, she was not in the room at that time, correct? Colleen Dowdell was not in the room at that time, correct?
I don't believe she was.
You said you believe she was?
I don't believe she was.
Okay, thank you. Now, you went back to the room later with Officer Ogle, correct?
Yes, ma'am.
You did not get her to reaffirm what she told you in front of a witness, correct?
I didn't know.
The female EMT, you did not get her to affirm that in front of her, correct?
Correct.
As a matter of fact, you never told the female EMT on the scene that night of what you have told us about what the complainant supposedly said, correct?
I think I told the EMT that she refused medical treatment.
Which is not documented in any report, correct?
My reports are synopsis, ma'am.
So the answer to that question was it was not documented, correct?
Correct.
My question specifically to you was not whether she was refusing medical treatment. My question to you is specifically, did you tell the female EMT on the scene that night that the victim told you she was not sexually assaulted, yes or no?
I don't recall if we had that conversation or not.
Okay, you don't recall telling her that.
I don't recall having a conversation with her.
Okay, but you recall having a specific conversation about not needing medical treatment, but you don't recall whether you actually told her she denied being a victim of sexual assault, correct?
Yes, ma'am.
Judge, the court has ruled innumerable times about the proper language complainant vis-a-vis victim. If this officer is to believe, and I have no reason to disbelieve him, this woman indicated that night she was a victim of nothing. And so to say that this victim of criminal sexual assault assumes facts, not evidence, is conclusionary. It invades the province of the court. Just for the record, I know the court can distinguish it. And I don't want to keep jumping up and down.
Because I can. Proceed.
Now, the first report, you wrote your activity log that night.
What are you approaching him with?
To show him his activity log
You
again.
didn't ask
Okay.
him about his activity
Okay.
log. You didn't show it to Mr. Lindsay. You didn't ask Mr. Manley. Sorry. Lord, what a guffaw that was. You didn't ask my permission to approach. Get your courtroom decorum in order.
Your activity log that you prepared at the end of the shift that night. You did not include any of that information in your activity log, correct?
Correct.
You did not.
Directed to appear as the court.
I don't know.
Is the
I'm
court
waiting.
direct? Court just told her direct us to what.
I'm
she's
waiting,
referencing.
Mr. Manley. So far, she hasn't stepped over the line. I'm waiting.
Okay, I'm questioning him about his activity log,
I
which
understand.
he previously had seen. So what does the court direct me to do?
Nothing yet.
Okay, thank
You're
you.
doing just fine.
Thank you, thank you. So when you went and you prepared your report at the end of your shift, you did not include any of that information in that activity log, correct?
Correct.
You didn't put Mr. Cleaves' name, correct?
Correct.
You didn't put the complainant's name, correct?
Correct.
You didn't put the names of any of the people that you supposedly talked to on the scene, correct?
On my activity log, no.
As a matter of fact, you did not tell any on scene, excuse me, let me back that up. There are supervisors back at the station, correct?
Pardon
During
me?
your shift. Are there supervisors on duty at the station, correct?
At night?
Yes.
No.
Excuse me?
No, ma'am.
Okay. Are there detectives on call?
Yes.
You didn't call any detectives on call to inform them of any of this, did you?
No.
When you got back at the station, you didn't inform anybody or leave any notes for anybody about this, correct?
Correct.
Now, you didn't take any detailed statements from the man that was there, correct?
Which man are you referring to?
The man that we saw in the video. You didn't take a detailed statement for him, correct?
Correct.
You did not take a detailed statement from the female that was there, correct?
Well, we spoke, ma'am.
My question to you is, did you take a detailed statement from her? Yes or no?
I don't know how to answer that question, Your Honor.
Can you approach?
Thank you, Blaine.
Just a moment till we get back on the record, please, Ms. Windsor. We're on, go ahead.
Did you take any type of detailed oral statement from the female at the scene? Yes or no?
Again, ma'am, I don't know how to answer your question.
Are you talking about the complainant? Are you talking about witnesses?
I'm talking about the female witness, Ms. Dowdell. Did you take a detailed oral statement from her?
We spoke?
My question to you is, listen,
Okay.
detailed oral statement, simple, yes or no?
I'm unable to answer the question, ma'am.
Okay. Did you take a detailed oral statement from the male that was there?
No.
Did you take a detailed oral statement from the night manager?
No.
Matter of fact, you spent less than 3 minutes with Ms. Dowdell, correct?
I don't know how long it was.
You wouldn't dispute that, would you?
I won't dispute the video if that's what it says.
Okay. So if the video shows you spoke with the female less than 3 minutes, you wouldn't dispute that, correct?
Which female are we talking about?
I think she's talking about the witness.
Ms. Dowdell, you wouldn't dispute that, correct?
I would or wouldn't dispute
You
it?
would not.
Oh.
Okay. If the video showed your contact with the male was approximately 2 minutes, you wouldn't dispute that, correct?
Which male are you talking to?
The male that was near the room.
I won't dispute that.
And as it relates to your contact with the manager, your contact with her was not in relationship to what happened, but was merely whether Mr. Cleaves could leave his vehicle there, correct?
I don't remember the conversation we had.
Okay, if you don't remember the conversation. And that certainly wasn't put in any type of report, correct?
Correct.
Now, you did not knock on any doors, is that correct?
Correct.
You did not attempt to view the video, correct? That's a yes or no.
I can't answer the question yes or no then.
Did you attempt to view the, that's a yes, Judge, can you instruct him to answer that question, yes or no?
I can instruct him to do it, we'll see what he says.
The answer is not yes or no, ma'am.
Okay?
It's a detailed answer, and I'd be more happy to give it
I've
to
already
you.
heard it on direct exam anyway.
I'm not asking you why you didn't, I'm asking you, did you do it?
Okay, no, ma'am.
Okay. And you have been to that location on numerous occasions, correct?
I have.
And you are, you consider yourself to be a trained and professional police officer, correct?
Sure.
And you never noticed on the many times that you were there that there was a video camera a few feet away from where you were standing that night, correct?
I didn't realize or know there was a second video system on the hotel.
So the answer to my question is, you did not know, after all the times you've been there, you never noticed a camera a few feet away from where you were standing, correct?
I didn't know that. No.
And your answer was, in the past, you haven't been able to do video from that location, correct?
One more time again.
Your answer as to the reason why you didn't try to look at videos because on previous occasions you didn't get good video, correct?
The video is not of quality in that area of the hotel on the original system.
On previous occasions, correct?
Correct.
Did it ever dawn on you that they might have updated since the last time you looked, correct?
I'm gonna let her answer.
Did it ever dawn they put a second video
Did it
system?
ever dawn on you that their equipment they could have updated their equipment since the last time you looked, correct?
No, it didn't dawn on me.
Do you believe it's a sound investigatory technique to rely on just because something happened in the past, I shouldn't try this time? Is that a sound investigatory technique?
No.
So you would agree with me that you probably should have tried to look at it, correct?
That I should have looked at the video.
You should have tried to see whether there was video, correct?
I'm aware of the video because I've used it prior to this.
I'm not asking you that.
Okay.
You already said it's not a sound investigatory technique just because you didn't get something in the past not to do it. You already admit that, correct?
Well, I think that's in a broad statement, ma'am.
Ms. Lindsay, Mr. Manley, I'm sorry, this court needs to take a recess now.
Okay.
We will reconvene in approximately 7 minutes.
Thank you, Judge.
Could be closer to 10.
Clear your throat too much. You couldn't hear it.
Okay, right about now.